Okay, everybody, it's 10 o'clock. Good morning. Welcome to November 10th. We are going to be talking about the Naples Area Board of Realtors, new changes to the sales contract, the as-is, the vacant land, and the disclosures. I'm very excited. I served as the scribe for the committee and the vice chair this past year under the excellent leadership of Jeff Jones. He was great. And I'm looking forward to showing you what we've done as a committee. A couple of things right up front. This is not a NABOR sanctioned or CE credit presentation. This is just my presentation, my thoughts and my notes on the contract. It does not create a legal attorney-client relationship. We are just going to be going over some information, and if you have questions, you can put them into the chat or unmute yourself and ask your question. I'm looking forward to hearing your thoughts. And a little bit about me real fast. I see a lot of familiar names on here, but I've been an attorney now for almost 19 years, actually over 19 years now, just this month. And I've been practicing real estate law for 15 years in Southwest Florida. My offices are in the Cape, Bonita, Naples, and Marco. And I am looking forward to going over this contract with you, and we're going to get started right away. So hopefully everyone can see my screen. We're sharing the sales contract, residential improved property, vacant land as is, listing agreements, forms, and disclosures. And let's just dive right in. Right here. Now, what I'm going to do is I have cut and paste and put screenshots of the red line that we created as a committee at NABOR, and I'm going to go over the changes. And then again, if you have questions, just interrupt me. So right off the bat, at the beginning of the contract, we updated page 1 of the contract, the portion that describes what's being sold. So you have your real property that's being sold, and then you've got your beverage coolers, your attached lighting, your ceiling fans, all that good stuff, your integrated home automation. And we added, of course, that includes smart home components. So you've got a clarification that's the smart home components. And then we add electric vehicle charging equipment, including all operational components. So for those of you that like Tesla or some of these other new ones, and you've installed a charging station in the home, that now conveys. The other thing that conveys are the access codes to doors and gates, things that you might have added that create security around the home. That all transfers with the keys, the fobs, and the other access devices. So that's just a clarification. Next up, in the financing section, I put a small cutout of what the new financing section looks like. We made it easier to read. We left justified your choices, and we reformatted it so that you just check the box for cash, check the box for buyer financing, and then there's another box for seller financing down at the end. And we just made it clear that you pick conventional, VA, FHA, or other, and then you put in your initial or fixed rate of interest down here. So it just lays it out a little bit easier. Should make it much, if it's left justified, the thought was you'd be able to find the boxes easier. I will say there have been no substantive changes to the financing provisions of the NABOR contract. So that is all as you know it, where you have the typical 45 days to get your financing, and then either party can terminate. The next change in the inspection section, excuse me, in the inspection section, we took out the old choice for due diligence inspections. Buyer reserves the right to conduct inspections and do it as is, and then you would include the attached as is addendum. What we did, it doesn't make any sense that you would check the box for an as-is contract if you're making an offer. You would use the as-is contract. So why would you use a regular contract to make an as-is offer? You wouldn't. But there may be the case where the seller wants to counter with an as-is when you make a regular offer. So the old as-is addendum that was attached with this old choice B is still available in the forms library. If you were to, for example, make an offer and you check box A, and then the seller came back and wanted an as-is, instead of changing the checkbox to due diligence inspections, they would simply attach the as-is addendum to their counter offer, and then the buyer would either accept or reject the counter, and we'd go forward or not. And the other thing I'm going to point out, do not pay attention to formatting in these, because all the formatting with the red lines is off a little bit. So when you're looking at the final product, for example, I believe this box is on the correct line. The other thing is, you'll notice I don't include any line numbers on my slides for a very good reason. The line numbers that I would have on my red lines are going to be totally different than the red line than the line numbers you're going to see when you go to use the contract in your forms library, be it, you know, the zip forms or anything like that. Okay, moving right along, the next change is to the survey and title policy section. I want everybody to cheer. No more $150 penalty in the contract. That was deleted. And the seller now needs to provide any of the owner's title policy or that's in their possession. So that $150 penalty that drove so many people crazy is now gone. Let's see here. Next up with the survey objections. So the survey used to have to be certified to the seller. We changed that. It no longer has to be certified to the seller. It has to be certified to someone in the chain of title, because that's what the underwriters require, the title underwriters. So it's a survey provided by the seller showing improvements to the property or the real property. And the other thing that we added is a new survey objection right here. This new survey objection says that if the property does not meet the local government development standards, i.e. the lot is too small, the lot is not wide enough, the lot is not deep enough, the square footage, again, is not correct, or there are other issues. If the real property does not meet the applicable development standards of the local government jurisdiction having jurisdiction over the property and is otherwise not deemed legally non-conforming, there's a lot of knots in there, then you would have a survey objection. What this means is when you get into like Old Naples and you've got those 33 1/3 foot wide lots, those original lots in Old Naples, and now you used to need 2 of them, and now you need 3 of them to have a buildable lot, because you need 7,500 square feet with 75 foot of frontage as your minimum. And that's in Old Naples, not everywhere. So you would have a survey objection, and that has come up a couple of times in various places where the lots have been moved around. And so we corrected that. Okay. Next up, the next one, insurance claims. The seller now has a continuing obligation to disclose any insurance claims filed or to be filed for damage to the property. Obviously, after Irma and then Ian, we have had a lot of issues about what the seller's got to disclose in terms of insurance. And so we corrected that. So that now the seller has a continuing obligation. So if you go into contract, Ian or Nicole or Irma or anybody else shows up and wrecks the place and you get an insurance claim that you need to file, you would have an obligation to let the buyer know that. And obviously that affects the buyer's ability to get insurance on their own. So you now have to update the buyer. Okay, community investigation section. This is in standard D1. The community investigations basically says that the buyer is advised that they need to review what's going on in the association and what we did is we added ambient noise levels. And what happened was the airport requested, the Naples City Airport requested that we add an entire paragraph almost about noise levels related to the airport. And that we said, well, there's more than just airport noise. So we added ambient noise levels as something a buyer should investigate. Okay. We have a couple of questions. Let me just pause for a moment and get those questions answered. Terry is asking, what would happen if you had an objection on the survey? Seller would have to rectify it before closing, correct? Terry, survey objections are treated as title objections, and if it's not rectified, the buyer has up to 5 days prior to closing to raise a survey objection, and then the seller has 30 days from receipt of the objection to fix it, and that could extend closing. If it doesn't get resolved within the 30-day clearance period, then the buyer can terminate. Debbie is asking, what would happen if there is an issue after the storm and seller discloses and buyer does not want to move forward or cannot get insurance? Can buyer cancel without a penalty? Debbie, if you cannot get insurance, we didn't change that in the contract. If you cannot get insurance, then the buyer can terminate. Okay. Up next, the seller's maintenance obligation. So we expanded the D2C obligation of the seller to maintain the property to include curing any and all violations documented by the association. So what we did is there has been many issues with the associations noticing violations like after the effective date or of the contract or after the estoppel has been issued. And now the seller is obligated to repair all of those regardless of the timing of the violation notice. So if you get notice for a violation prior to closing, it's going to be a seller issue. And if there are fines issued prior to closing, that could carry over because of the notice of violation. There is an escrow of 200% of the estimated cost to repair the issue causing the violation and pay the fines. So it broadly expands the seller's obligation to remedy defaults with the association. The other thing I'm going to say about associations in this contract, I should have mentioned this at the beginning. We have, you can see here this capital A. We have removed references to co-ops, communities, homeowner associations, and condominiums throughout the contract. And we now refer to them as association or associations. And on the last slide for the contract, I'll show you we added a definition of association, which includes homeowners, condos, and co-ops. It's a much cleaner and easier to read contract now in that regard. And so I'm very excited about that change. Okay, up next in the seller's expense section, standard E of the contract, we talk about how the seller's got to pay the utility estoppel fee. They've got to pay outstanding balances due on utilities and for all utility services to the closing date. They've got to pay all outstanding balances and fines due to the association. And they pay for the 8288, 8288, and or 8288B forms for FERPTA. They also are going to pay for the reasonable fees to a buyer's attorney or closing agent for remitting the FERPTA funds and forms. So that means now it was always thought but unclear that the seller paid for FERPTA. Now it's clear, sellers pay for FERPTA. The other thing is if the buyer chooses to take an assignment of an insurance and service contracts, that is now something the seller's got to transfer whether they want to or not. Okay, let's see. A couple of questions up here. Sam is asking. Sam, you're gonna have to clarify your chat question.
if there's an association violation, does that, that's in addition to a buyer's election, seller's response, you don't have to say, hey, fix these things in the buyer's election, seller's response because the association said there's a problem with the house.
Yeah, the seller has a continuing obligation to maintain the property, and then they've got to keep they can't have any violations at closing. So that would have to be fixed. That would be fixed or escrowed. Okay, Bob is asking on the finance contingency, if the property is not appraised, what documents the buyer need to give the seller to get their deposit back? Bob, NABOR provides a seller provides a finance termination document, a form that the buyer would sign, and then depending on the title company or a closing attorney doing the closing, you would sign a deposit release directive as well. And then Daniel is asking, can you explain more about the Old Naples property size example? Would the buyer not be able to close a sale if the lot is too small to build on, unless they could buy the adjoining lots up to 3 total to meet the size limits? Daniel, that's correct. If you were in Old Naples, and this case came up when I was on the city council, and you had like 2 of the old 33 1/3 foot wide lots, and you needed 3, you would have to go buy the neighbor's property, or you couldn't build. And so what we did in the contract was we made that as a survey objection, so the buyers can get out of the contract in that situation instead of being forced to buy and then negotiate with the neighbor or lose their deposit. So we thought that was not fair to the buyer if the lot is an illegal lot. So, okay, let's double check. No other questions there. All right, moving right along, association approval. So it's always been, as far as I know, in the NABOR contract, that if the buyer did not get association approval by the closing date, then either party could terminate the contract. But what happens when the buyer doesn't have association approval because the buyer didn't apply in a timely manner? Well, it used to be that the buyer could get out and get their deposit back. This is no longer the case. This is somewhat of a substantive change, and you need to be aware of it. You need to be aware of the timing. Not later than 10 days after the effective date, the buyer needs to make application. See this right here? I'm circling it. If the buyer does not make application to the association in a timely manner, that is within 10 days of the effective date, the buyer does not get their deposit back on the closing date if the application is not done. The other thing is in this section that sellers are not getting their violations remedied or agreeing to remedy violations and pay fines, and then the association is withholding applications, and then we're getting to the closing date and the seller is terminating because they don't want to deal with the association fines and the association violations. So now seller's right to terminate under this standard J is conditioned upon there not being any violations of the association's documents and past due balances. So those past due balances have to be paid at closing. And again, we escrow for violations and we go to closing and we negotiate with the association to get that taken care of. Okay, a couple more questions before I move on. Noise level section regarding HOAs at the airport. Where is there an issue with too much noise in specific neighborhoods? Daniel, it's just a general request by the airport to put a noise notice in the airport. We rejected the airport's specific request and just put that ambient noise level language as something a buyer should be aware of. Tammy is asking, what if the listing agent doesn't provide the application and or the seller needs to sign and doesn't do so in a timely manner for the buyer to apply within those 10 days? Tammy, the contract and Florida law, this is a great question. This is a very good question. What happens if the seller's being uncooperative and doesn't want to sign the application? Maybe because they know there's violations they're going to get dinged on. Maybe because they're in a fight with the association. This is very common. And if Florida law and this contract require the parties to exercise good faith and diligence in their efforts, and if they don't do that, then there's a breach of contract and we have to have a deposit dispute and possibly a specific performance suit if the seller is not cooperating. So it gets a little messy, but it's the best solution that we've got. Okay, next up is the defaults and remedies section. It was always believed, and it's been done many times, that the seller would terminate the contract if the buyer defaulted, and they get to keep all deposits made. But it never actually said in the contract that the seller may terminate this contract and get the deposit. Now it does. So if the buyer defaults, seller can terminate and take the deposit. If the seller defaults, the buyer can enforce the contract for specific performance damages or terminate. Okay. Anita is asking about insurance. If the buyer is unable to get insurance quote, but closer to closing, the premium is adjusted much higher. What are the buyer's rights under this kind of? Anita, that's kind of outside the scope, but just very briefly. If insurance rates are unreasonably high, if insurance rates are unreasonably high, then the buyer could get out of the contract under the risk of loss provisions. We didn't make any changes to that, so I don't have a slide on that today. Okay, major change on this one. There it is. No more texting. You cannot text your notices under the contract. You can certainly communicate with the other agent by text message, and you can talk it out over the phone like you always could. But when it comes to official notices in the contract, no more texting. You must deliver notices in writing by U.S. mail, personal delivery, electronic mail, or facsimile transmission. SMX communications shall not constitute proper notice. And it's in big, bold, red letters in the contract now. That is just, there's been some bad case law on texting. There's been a lot of problems with listing and selling agents fighting with each other over text message and not putting things in a formal written disclosure once they resolve the issue. And so just no more texting. You can text with each other, but when it comes time to do the contract and the notices, it's got to be a writing, and you got to use one of the 80 forms, or we got to write it up with your favorite closing attorney. Okay. Shelley is asking me to repeat the previous screen regarding the HOA disclosure. Shelley, this is just simply that the buyer and seller have to be in good faith before they can terminate. That's probably the easiest way to say that. Up next, I said I would do this is the last change, really. There's one more change, actually. This is the last major change to the contract. We define association now as all HOAs, condos, and cooperatives under the statutes that govern them. And you saw in the changes where the little a was now a big A before association, and we deleted condo and co-op language. So just associations in the contract could be any of those that govern the property. Terry is asking on an as-is NABOR, can the buyer still back out if they can't get insurance? Yes, they can. Okay, so at the request of many realtors over many years, we now have check boxes in the NABOR contract for the addenda that are provided by NABOR to you for your use with the contract. The following addendums, if attached here too, note it has to be attached there too, are incorporated into this checkbox, into this contract. And then you check the box for the addenda that you're going to use, and then you attach the addenda to the contract, and voila, we are in contract. And then, of course, this didn't change. The addenda controls over the wording of the contract. But you have the other box down here. See this? Circling it. This is for blank, the blank addenda form. You can use the blank addenda and you can write up other terms, but remember, that's probably practicing law without a license, and you need your favorite closing attorney to look at it. Okay, couple of questions about the contract, then we're going to switch over to the listing agreement real fast. So, okay, so Rosaria is asking, or sorry, Bathia is asking, for the HOA violation, can you restate the violations part if the seller has any? Seller can cancel? No, Bathia, the seller cannot cancel if they have HOA violations. If the seller does not cure the HOA violations by closing, then we escrow 200% of the estimated cost to cure the violations, and we go to closing. The NABOR contract is designed to keep the deal together. That's been one of the overarching goals of the committee since I've been on it. It is designed to keep the deal together, so it's very hard to get out of. And the reason for that, of course, is we don't want you to have to waste your time going under contract after you spend all your marketing dollars on the property and then have one of the parties pull out because they feel like it. Yvette is asking us the color differences are just formatting changes of that. It'll all be in black when you get to the contract. You know, by the way, I will send out these slides. I will not send out the NABOR red line. That's for NABOR to do, but I will send out my slides with my notes after this presentation. I'll email everybody. I've got all your emails. Somebody's back here. Why is the CDD addendum not a checkbox on the contract? Back here, the CDD disclosure is not an addenda. It's not an addendum. It's a disclosure, and it is checked in the box under CDDs, which incorporates that disclosure into the contract, up in the contract. So it would not be listed here. Kathy Ahern is asking in regards to insurance, what constitutes unreasonable? Kathy, that is what 12 members of a jury decide. Reasonable, you know, they teach you reasonable on the first day of law school, and then you have to figure it out over the rest of your life as a lawyer. So I can't say what reasonable versus unreasonable is. I would say if it's significantly above the market that's average in the area because of the property itself, that's probably unreasonable, but I'm not the judge or the jury. Okay. Maria does not include closed claims, open claims. Maria's asking whether you have to disclose closed insurance claims. Okay, let's move on to the listing contract. So the listing contract, this is very, very few changes. Just want to point out 3 things. We changed it throughout the listing agreement to match the changes in the sales contract. So I'm not going to go over all those again, but just the FERPTA expenses, the seller expenses, those all match. And what we did was we added attorney's fees in the listing agreement. This is kind of a big deal for you guys in that before, when you had a dispute with your seller, you had to pay your own attorney's fees, whether you won or lost. Now, if you win, the seller's got to pay attorney's fees. Of course, if you lose, you pay seller attorney's fees. So be very careful. And then we match the definition of association in the contract. And then the other thing we did in the listing agreement, I did make a slideshow of this. We did add check boxes to the listing agreement. We only have 3 addenda for the listing agreement, so they're just added to the listing agreement as check boxes there too. Okay, I don't see any other questions. Any questions on the listing agreement real fast? Really, really simple stuff, so not a whole lot. I don't see any. Okay. Let's talk about the minor changes to the addenda and the disclosures. On the backup contract, we added an advisory that the parties should seek legal counsel. I'll say this about the backup contract. On backup contracts, when you take multiple backups, you have to be very careful that you do not obligate your seller to sell this property to multiple backup offerors, because you didn't clarify in the backup addendum that there was an order to the backup offers, and that the buyer has to wait their turn if they're like second or third in line. So just be very careful using that. We added an advisory. On the post-closing occupancy, the buyer may now have access for purpose of storing personal items after closing. We've had several issues with sellers who won't allow access to buyers during post-closing occupancy periods, so we clarified that. On the right to make a backup contract, the primary contract, it's now subject to the MLS rules regarding active versus pending listings. So if you've got a pending listing and you want to take backup contracts, you can do that, but you can't change it back to active. And that was always a question, and now it's clear. And then on inspection election notice, everybody's favorite form that I can't stand, but we have to use it. We added an advisory, do not use the inspection election form on as-is contracts. If you have an as-is contract and you negotiate inspection items, we need to draft a specific amendment to that contract. That amendment's got to say not just what all the changes and fixes are going to be, but the remedy in the event those changes and fixes are not done by closing. And that's always missed by parties when they're negotiating. They say, you know, they agree to fix the water heater, they agree to tighten the toilet, they agree to get the air conditioning running. And then what happens when that doesn't get done by closing? Contract is silent. So we've got to make sure that we have provisions in the as-is amendment that we draft to allow for what happens after closing. Let's see here. Let me just go through. I got a couple of questions before I move on to insurance disclosures. Is it wise for the seller to fill out an insurance disclosure if it was a rental and they never lived in it? Sam, I'll go over that separately with you because that's kind of outside the scope of this presentation. The short answer is I don't like sellers disclosures that much, but they serve a purpose in the NABOR contract. Yes, this contract will be on YouTube, Darren. Andy is asking if there are several backup offers. Should the seller be able to ask for highest and best? Yes, they should. The seller should call for highest and best, and then you can make a decision. That's kind of a technique, though, that listing agents and your brokers like to use. So I'm going to leave it to them to give you the specifics on how to best do that. But calling for highest and best is often a technique that you use to get your best offer. Okay, the next thing we made a change to the insurance disclosure. Used to be flood insurance only. Now it's for all insurances. We took out the NFIP language and we added state and federal. So if you want to give a disclosure related to insurance, you can now give a general insurance disclosure. Okay, let's see. Yeah, yes, Patsy, you're correct. You want to use a blank amendment form, not a blank addenda form. If you're using FAR contracts, they don't provide a blank amendment. So you could use the addenda form, but NABOR provides a blank amendment form that's better than an addendum form for modifications to your as-is contract. Becky is asking, can you review the listing agreement change again? Becky, the only change really to the listing agreement was just these three items. And I'll email this out to you, you can see it. But the red lines will be available December 1st, by the way. And on December, so you'll be able to see all this stuff on December 1st in the contract itself. Okay, the last thing that I've got to go over with you, and this is super important. We provide now a new disclosure. I call it a hurricane disclosure, but it's not really, that's a bad title for this slide. What it is an inspection disclosure. On July 1st, the Florida legislature enacted new laws that require structural integrity inspections, and they require integrity reserve account studies. And what the law now says is If a building is older than 30 years old and it's more than three stories or more tall, or if it's within 3 miles of the coastline and it's 25 years or older and 3 stories or taller, then you've got to do a structural milestone inspection. That structural inspection looks for cracks and other structural issues. It must be performed by a licensed Florida architect or engineer. The other study that has to be completed, presumably that's going to be done by an accounting firm, is a structural integrity reserve study. The condos have got to fund their reserves. They have to do it now. And there's going to be penalties for the directors and officers who don't do it. And buyers have to be aware, and we believe the legislature is going to make it so that buyers are going to be able to see these structural reserve studies and these account studies prior to closing. So be aware of that. And this notice is going to be very important for anybody who sells along the beach or in a high-rise condominium anywhere in the area. All righty, with that, I am going to open the floor to questions and say thank you all for your attention today. Go ahead if you want to unmute yourself and or put it into the chat. Take a few minutes here to answer any questions. Brittany, the contract changes are out. They should be in zip forms and form simplicity and all those. If they're not there now, they will be by December 1. Other questions?
Hi, Sam.
Yes, Sarah.
So ITC for my agents, and I just wanted clarification with it. It's saying with the addendum that it says, if attached, what if something was checked off but was not attached? Because it says if, is it still a required document?
It's a required document if you check the box. If you don't attach it and you don't sign it, it's not part of the contract.
Okay, so even if it's checked and it's not attached, it doesn't matter.
Right, that's why we said that, and that's why we added.
Okay, perfect. Thank you.
Yeah, we added. It's got to be if attached here too. So you got to sign it. You can't just check the box and don't do it. That's and the reason for that is really to protect the parties, so that if you check the box and they got to know what they're signing.
Okay, perfect. Thank you.
Nicole is asking, is it wise to have an attorney like yourself on retainer to review my contracts? What does this retainer run for the year? Nicole, if you want to have me review your contract, if you fill it out and get it ready to go, and then you shoot it over to me, I'll give you a quick look at it. I don't charge for that. So don't worry about that. Tammy is asking, if it's checked and not attached and signed, for example, a day later, does it change the executed date of the contract? No, it does not. Signing addendums a day later or making amendments to the contract after the fact don't change the effective date. That's a really good question. Louise is asking where you can do a will for a reasonable price. Louise, give me a call. We'll take care of that. Debbie is asking, is the structural reserve inspection part of the inspection paragraph of the contract? No, Debbie, it's not. The law was passed in July, but there's a lot of questions about implementation of the law. It doesn't have to be implemented until the end of the year. Or I'm sorry, the end of next year, end of 2023. So we're still working through that. We felt it was important to get this disclosure out, but not it hasn't been incorporated into the contract yet. Sam, do you have a question? You're unmuted.
Oh, no, I'm fine.
Okay. All right, other questions people might have? Katia? Okay, I think she's unmuted herself. All right. All right, everybody. Oh, Bob, do you have a question?
Yes, I just wondered about FERPTA. Who pays for the extra documentation associated with FERPTA?
Seller pays for everything related to FERPTA. It's seller expense, seller problem. And we clarified that in here, right here on this, if you look on the screen, that the seller's instrument expenses, seller shall pay for and provide when applicable the FERPTA charges.
Thank you.
Yes, sir. Bati, did you have a question? Fatia? Okay, guess not. Okay, Yvette?
Yeah, you were, excuse me, talking about in a certain circumstance that we need attorney help to add some information or verbiage about the remedy from the seller to fix
Yes,
items
ma'am.
after the inspection. Was it for the as is only or for both? And can you just go back over what needs to be added?
Sure. So whenever can't use one of the 80+ NABOR forms, and you've got to go to the blank addenda or blank amendment, blank addendum or blank amendment form, as a realtor, you really shouldn't be drafting extra contract language. But I know that we all do that. And so what I say is draft your addendum or your amendment, and then let me see it, and I'll help you get it into a proper form. And one of the things that is usually missed when you're using an as-is contract, they'll write up an amendment to contract that says, the seller's going to fix the water heater, seller's going to fix the air conditioning, but they don't say what happens if the seller doesn't get it done by closing. Is it a condition of closing? Do you do the escrow? You got to put all that in one of those amendments.
Okay, so that's what you meant by remedy.
Yep.
Thank you.
I do have a question if,
Sure, Sam, go ahead.
okay, back to the HOA seller violations. Of course, they can't terminate the contract because they have fines or violations at all. And it has nothing to do with the buyer's election, seller's response. So if a week out from the closing, the association says you have a $5,000 fine and you have 6 things you need to get done on the seller violations, repairs on your house or condominium, basically there's a 200% holdback, I think you said, or they have to do the work. Does the work have to be done? Or if the parties agree on a credit, that's enough? And if they agree to do the work, the seller, and it's not done, it's a 200% holdback.
Here it is. So the seller has got to they got to remedy and cure all violations prior to closing. If they don't get it cured prior to closing, then there's a 200% escrow.
Okay.
If there are fines that are associated with the violation and they have not been paid at closing, maybe because the violation is not done at closing, then you would have a post-closing escrow for the fines as well.
Okay, but you could still close, but there would be holdback money on fines and of course repairs.
Exactly. That's exactly
Thank
right.
you.
We always close.
Thank
My
you.
office, we always close.
Absolutely. Thank you.
Yes, sir. Okay. Sharon's asking if I charge any fees for language on the blank. I usually do not, Sharon. If it's really complicated or takes a long time or I've got to do a bunch of negotiations, I might do it. And I would never charge if I was doing the closing. I just include that in the closing fee. So that's kind of how I manage that. So Batia is asking if you can explain again about the check boxes. If like a condo rider comes with the contract, so you wouldn't use a condo rider, Batia, on this contract like you would on a FAR contract, because the NABOR forms actually include all of the required association language in them as a default. So you wouldn't attach a condo rider per se, but if it does come back after execution, then it would technically be an amendment. Pamela is asking, my closing fee depends on the purchase price, Pamela, but it's typically $650. Okay, other questions? Let's see here, Charles. What if there were additional interest charges on the fines that were held in escrow because it wasn't paid? Should 200% be held? Yes, it should, Charles. If you got fines that are accruing, daily fines, or there's interest charges on those fines, that all gets to get escrowed and we pay it after closing if we don't know what it is at closing. All right, everybody, I promised 45 minutes. It's been 44 minutes, so I'm going to say thank you very much. I really appreciate you all taking your time to listen to me today. I hope I've been helpful. And if you have any questions, you can call, text, email, smoke signals. Right here is my contact information, sam@saablegal.com, or text me at 239-784-5556, or give me a call. I'll talk to you all soon.
Thank you.